Mr. Paul. My Lord, my Lady, I move then to what I've described as the second question, which is the appellant's argument that it is inconsistent with the principle of the separation of powers for the legislature to prescribe the mandatory death penalty for murder. And we address this, if your Lordship and my Lady's note, at paragraphs 119 to 125 of our printed case, which is pages 375 to 377. There's essentially three steps in the respondent's argument. The starting point is to recognise that it is preeminently the function of the legislature to determine what conduct should be criminalised and punished. And in Trinidad and Tobago, that is recognised in section 53 of the Constitution, which provides that Parliament can make laws for the peace, order and good government of Trinidad and Tobago. The next step is to recognise that Parliament is entitled to prescribe a fixed punishment without usurping the judicial function. And that, in my submission, is a well-established common law principle recognised in cases such as Deaton, Hines and Mollison, and in fact a survey of most open and democratic societies, and certainly those based on the Westminster model, reveal that mandatory sentences are not regarded as being inconsistent with the separation of powers. The rule is not that Parliament must leave the choice of sentence to the court, but rather if the choice is left to the court, rather than being fixed by Parliament, it must be the court that exercises that choice and not some other body. And then the third step is to recognise that that common law rule applies to all fixed penalties, even the most severe. And that is expressly recognised in Hines and endorsed by the minority in Rudall. And so in my submission, it follows that the legislature is competent to fix a penalty of death as much as any lesser penalty without infringing the separation of powers, subject, of course, to sections 4 and 5 of the Constitution. And this is because the function of the legislature is checked by the Constitution, and such checks are enforced through the courts. That is the separation of powers in operation. And as Lord Diplock said in Hines, sections 4 and 5 impose a fetter upon the exercise of the legislature, the judiciary, and the executive. And here, section 5(2)(b) of the Constitution makes specific provision for the vice complained of, namely a disproportionate penalty, but the Constitution has specifically preserved the mandatory death penalty by virtue of section 6. So whilst a disproportionate penalty may constitute inhuman punishment, it is not inconsistent with the Constitution and not a breach of the separation of powers. And as I said before the adjournment, even if the board was to find, contrary to our case and the majority in Matthew, that section 6 did not preserve the mandatory death penalty, the appellant's separation of powers argument remains without merit, because it is not a complaint about the separation of powers at all in my submission. It is a complaint that the legislature, by enacting section 4 of the Offences Against the Person Act, has acted in breach of section 4 and 5. And that, as I also submitted before the adjournment, is because what is objectionable is not the legislature prescribing a mandatory sentence, but the sentence being a disproportionate penalty. In other words, a complaint not about the qualified separation of powers, but a fundamental rights complaint. And again, it links to what I submitted earlier, that the express provisions of a constitution must be assumed to be the way in which Parliament has chosen to give a practical expression to the underlying structure and principles, which include the principle of the qualified separation of powers. Proposed to take the board to a few authorities to make good those principles. And the starting point is the Supreme Court of Ireland's decision in Deaton, which has been approved by the board in several subsequent cases, most notably Hines. But if we start with Deaton, Deaton's at page 1999. And as can be seen from the head note in Deaton, the issue was whether a provision that conferred on the revenue commissioners the power to elect which of two penalties the court was to impose for a customs offence was unconstitutional on the basis that it conferred a judicial function to the executive. And Chief Justice O'Daly gave the judgment of the Supreme Court of Ireland, draws the distinction between the prescription of a fixed penalty and the selection of a penalty for a particular case. If I can refer the board specifically to 2011, and the last paragraph on that page that starts "in my opinion," he says there's a clear distinction between the prescription of a fixed penalty and the selection of a penalty for a particular case. The prescription of a fixed penalty is the statement of a general rule, which is one of the characteristics of legislation. This is wholly different from the selection of a penalty to be imposed in a particular case. It is here that the logic of the respondent's argument breaks down. The legislature does not prescribe the penalty to be imposed in an individual citizen's case. It states the general rule, and the application of that rule is for the courts. In the later case of Whelan and the Minister of Justice, which the board have at page 4907, the Supreme Court of Ireland held that the imposition of a mandatory life sentence for murder was not incompatible with the Constitution. If I could just ask the board to turn that up at paragraphs 40 to 52 of Whelan, which is page 4924 is where it starts. And we've set it out at paragraph 120 for convenience on our written case, which is page 375 to 376. And citing Deaton, the Supreme Court held there that there was nothing repugnant to the separation of powers for the legislature to fix a mandatory life sentence for murder. And Whelan, as we make the point in our printed case, was cited then with approval in a more recent Supreme Court of Ireland decision. That's the case of Ellis, at paragraph 59, which the board have at page 2290. And again, the relevant passage is quoted in our printed case. Now, the board has endorsed the principle in Deaton in a number of other cases. Now, if I can draw attention first to Hines. Now, obviously, we've already looked at Hines when addressing the first issue under the separation of powers. The issue of the separation of powers in the context of criminal sentencing in Hines is addressed by Lord Diplock at page 2680. Starting at letter G, he says, in the field of punishment for criminal offences, the application of the basis principle of separation of legislative, executive and judicial powers that is implicit in the Constitution and the Westminster model makes it necessary to consider how the power to determine the length and character of a sentence which imposes restrictions on personal liberty of the offender is distributed under these three heads of power. The power conferred upon the Parliament to make laws for the peace, order and good government of Jamaica enables it not only to define what conduct shall constitute a criminal offence, but also to prescribe the punishment to be inflicted on those persons who have been found guilty of that conduct by an independent and impartial court established by law. Skipping 4 lines to letter B over the page of 2681, in the exercise of its legislative power, Parliament may, if it thinks fit, prescribe a fixed punishment to be inflicted upon all offenders found guilty of the defined offence, as, for example, capital punishment for the crime of murder. Or it may prescribe a range of punishments up to a maximum in severity, either with or, as is more common, without a minimum, leaving it to the court by which the individual is to be tried to determine what punishment falling within the range prescribed by Parliament is appropriate in the particular circumstances of the case. The board has in our printed case references also to the case of Ali and Mollison, where Deaton was subsequently approved by the board. It's paragraph 123 of our written case, page 376. If I can just give the board the specific references to those two cases. Ali, separation of powers, is addressed by Lord Keith at page 992, where he cites with approval Lord Diplock in Hines and Deaton. The case of Mollison, which we've already been to, but on this point, Lord Bingham deals with the separation of powers at paragraph 12, which is page 630, over to the top of 631. And Lord Bingham there notes Lord Diplock's recognition of the power of Parliament to prescribe maximum and minimum sentences by statute, and then quotes from Hines, quoting and citing Deaton. It's necessary also to mention Rudall. Now, the majority in Rudall did not consider the appellant's separation of powers argument, given their conclusion on Section 6 and the power of modification. See at paragraph 33 of Rudall, that's 728. But Lord Roger and Lord Millett do address the issue at paragraphs 105 to 109. And at 753, on the point in issue, namely the ability of Parliament to prescribe a mandatory sentence, Lord Roger and Lord Millett endorse what was said in Deaton. And as they say over the page 754, having quoted from the passage I've taken you to in Hines, at letter F, although Lord Diplock's comment on capital punishment for the crime of murder was obiter, it has stood for over 25 years, and we see no reason to question the Board's view that fixing a mandatory death sentence for murder is an exercise of the legislative function which does not offend against the separation of legislative and judicial powers inherent in the Caribbean constitutions. Now, as well as being cited by Deaton, the Deaton principle being cited with approval by this board, it was cited with approval in the House of Lords in the Anderson case. And I don't propose to take Lordship and my lady to that, just to give the reference. Anderson, the relevant passage is Lord Bingham at paragraph 23, which is at page 1055. And Deaton and Hines have been consistently applied and followed by the Court of Appeal in Trinidad and Tobago. And one example of this is the case of Francis. And the board have Francis at 2367. Would invite the board to turn up Francis, because Francis is relied on by the appellant and is cited at paragraph 74 of his printed case. And from what is said at paragraph 74, the board might be left with the impression that Francis supports the separation of powers argument. Whereas, in fact, the Court of Appeal of Trinidad and Tobago in Francis rejected the separation of powers challenge and unanimously held that it was well within the ambit of Parliament to provide a fixed penalty. And we can see the reasoning of the minority dissenting on a different issue at paragraphs 12 to 13, which is page 2378 of Francis, where they say the minority say Lord Diplock in Hines is a complete answer to the issue. And the reasoning of the majority in Francis on this issue of separation of powers at paragraphs 195 to 198, which is 2453. And the majority, having quoted Hines, refer to what was said by Lord Bingham in Rays at paragraph 25. And what is said by Lord Bingham at Rays at paragraph 25, again, I invite the board to have regard to that, particularly the last 6 lines of the passage quoted. And rather than taking you to Rays, it's set out in the Court of Appeal's judgment in Francis there at paragraphs 195 to 198. Now, there are many other examples of other democratic countries permitting the legislature to impose fixed penalties and leaving the sentencing judge with little or no discretion. We see that in the United States, Canada, Australia, South Africa. Now, obviously, some caution is necessary in cases dealing with federal constitutions. Nevertheless, what all those constitutions have in common, which has an important bearing in my submission on their interpretation, is that the principle of the qualified separation of powers applies to the functioning of all 3 organs of government. And that was a point that Lord Diplock makes in Hines at page 2666. And if I may just give the board, again, some references to make good that point. Australia, the leading case is Pauling and Caulfield. And the relevant passage is from the judgment of Chief Justice Barrack, which is 3834. I can just ask the board to turn up 3834. It is about 2/3 of the way down that page. where he says, "It is both unusual and, in general, in my opinion, undesirable that the court should not have a discretion in the imposition of penalties and sentences, for circumstances alter cases, and it's a traditional function of a court of justice to endeavour to make the punishment appropriate. But whether or not such discretion shall be given to the court in relation to a statutory offence is for the decision of the Parliament."
Well, presumably Article 5 of the Convention would impact on our sentencing powers. It can't be arbitrary.
My Lord, of course, and that's why I say in Trinidad and Tobago it is subject to the fundamental rights provisions in sections 4 and 5.
Yeah. So the case that you've just mentioned in Australia, they don't have the benefit of Article 5. So that provision, that sentence, but whether or not such discretion shall be given to the court in relation to a statutory offence is for the decision of Parliament. It's for the decision of Parliament, subject, of course, to Article 5.
Yes,
in this jurisdiction.
Yes, my Lord.
Yeah.
But they do have a provision in their constitution about judicial power, on which there's considerable jurisprudence. This is slightly surprising and early decision, perhaps.
My Lady, I entirely agree. They do, on all of these cases I take you to, which is why I say these are not, or this is not, and these were not separation of powers cases. They are fundamental rights cases, because the case I'm just about to take you to, the South African case of Dodo, and perhaps go there rather than talk in the abstract. You have it at 2048, and it's in particular paragraph 25, which is 2052. And at 2052, there is under our Constitution no absolute separation of powers, so this is South Africa, between the judicial function on the one hand and the legislative and executive on the other. When the nature and process of punishment is considered in its totality, it is apparent that all three branches of the state play a functional role and must now necessarily do so. No judicial punishment can take place unless the person to be punished has been convicted of an offence which either under the common law statute carries with it a punishment. It is preeminently the function of the legislature to determine what conducts should be criminalised and punished. Even here, the separation is not complete, because this function of the legislature is checked by the Constitution in general and by the Bill of Rights in particular, and such checks are enforced through the courts. So, in my submission, adopting and applying these principles, submit that by prescribing a mandatory penalty for the crime of murder, there is simply no encroachment by Parliament on the power of the court. And the cases that my learned friend Mr. Fitzgerald took you to yesterday afternoon, what was said about the imposition of the death penalty in cases such as Woodson and Mitu, that was said in the context of considering fundamental rights, not separation of powers. So Woodson was respect for humanity underlying the Eighth Amendment. Mitu was the guarantee of equality and right to life in India. There's no issue in the present case that imposing a mandatory death penalty infringes Section 5(2)b, subject, of course, to the argument on the savings clause in Section 6. And what I've already said once, if not twice, is what is objectionable is not the legislature prescribing the mandatory sentence, but it's the disproportionality of the sentence, which is a fundamental rights challenge. And for those reasons, we say that there's no encroachment here by Parliament on the power of the court. The third question, executive and judiciary, I don't deal with, given my learned friend for the appellant's indication it's not pursued. That leaves under issue 4 the rule of law. Now, as with the argument advanced by the appellant relying on Section 4b, protection of the law, and various other fundamental rights under Section 5, the appellant acknowledges that the rule of law argument is a new argument. And for the reasons already given by Mr. Stevens this morning, applying such cases as Baker and the Queen and the principles set out there, we do say that this is the board should not permit such a new argument to be advanced, particularly where the board has not got the benefit of the views of local court. And it is not necessary to determine it. But without prejudice to that submission, we do submit that the rule of law argument suffers from the same fundamental problems as the separation of powers argument, and essentially ought to be rejected for the same reasons. As we say at paragraph 158 of our case, where we cite the case of Dumas, which the board has at 2136, the rule of law is in fact upheld by the judiciary, upholding the supremacy of the Constitution. In the present case, this means giving effect to the plain and unambiguous wording of Section 6. And that's the point that was made by Lord Hope in Watson at paragraph 53. If I can ask the board to turn up 4885. Paragraph 53 at letter H. These are the provisions which require existing laws to be construed with such adaptations and modifications as are necessary, but these provisions are not part of the Constitution. They cannot prevail over what the Constitution itself provides, as it is the supreme law. Their lordships firmly believe that respect for the rule of law requires them to give effect to section 26(8) of the Constitution of Jamaica, not to ignore it, when it says that existing laws are not to be held inconsistent with any provisions of Chapter 3. We say that is the operation of the rule of law in this case. My lords, my lady, that's all I propose to say on issue 4. Issue 5 is dealt with shortly in our written case, and I leave it in writing. Effectively, if the board is not with the respondent and reconsiders Matthew and holds there is a power to modify, then the respondent does not oppose a construction of Section 4 that provides for a discretionary sentence of death. That's issue 5. Well, before concluding, my Lord Sales asked Mr. Stevens this morning a question about the CCJ's practice of observing precedent. We deal with that in our printed case. It's paragraphs 26 and 27, which is page 344. And I think Mr. Fitzgerald was right. The case that we cite in our printed case is the Attorney General of Barbados and Boyce, which is a CCJ decision. And the relevant paragraphs are 16 to 18, which is at page 1366 of the electronic bundle. And there's also something, albeit shorter, stated by the CCJ in the vase, paragraph 7, which is page 648. But essentially what Mr. Stevens told my Lord Sales is correct, but that's made good by what the CCJ say themselves in Boyce and Joseph. My Lord, my Lady, for all the reasons that we set out in our written case and that have been developed orally by Mr. Same, Mr. Stevens, myself, Respondent respectfully submits that the appeal against sentence should be dismissed unless I can be of any further assistance.
I think you're going to give us some examples of existing laws or altered existing laws that might be affected if the council is correct.
My Lord, that's right, and that we will do that. I think the suggestion was that is to be done sort of in writing after.
I think Mr. Hussain undertook to provide a note of. I think some judgments were to be provided, illustrating the application of Matthew locally.
I think there's a judgment, Suraj, the judgment which deals with the public health ordinance and regulations made under that. There's a judgment of Maharaj which deals with the Sedition Act, where the Court of Appeal in Trinidad have dealt with these arguments, applied Matthew, applied Section 6, and also, in both those cases, rejected the separation of powers argument on the same basis it's being advanced by the appellant in this appeal. Yes. And we can certainly provide those cases.
And obviously, if you're aware of other areas of the law that would be affected, then it would be useful for us to know about those.
So I think Mr. Stevens mentioned CPSAD, the 2013 CPSAD, and I understood that you would check to see if there were other
my Lord, we will, and we will let you have a note.
Thank you, Mr. Poole.
Yes. My Lord, on that last point, my Lord Reed mentioned more formal types of modifications. plead that there are instances of that, orders made under section 5(2). We will confirm that. I'm assuming there are other examples for the company speakers. I'm sorry we're not in a position.
No. Thank you. Mr. Fitzgerald.
Oh, yes. My Lord, I'm going to reply for us both. First of all, can I just make some points in response to the submissions of my own friend, Mr. Hussain, yesterday? Our first submission is that Section 6 does not trump Section 5 of the Constitution Act, as he said. The two provisions can be read together to produce a coherent constitutional regime. And the first point there is the same Act that creates the Constitution recognised both the need for a modification power and defined its limits in Section 6 by prohibiting invalidation of existing laws in reliance on Section 4 and 5. We do make the point that the power of modification isn't something that solely resides outside the Constitution, because Section 14 of the Constitution itself, the remedy clause, incorporates the power of modification. Indeed, that's one of the main remedies that is invoked for constitutional breaches, the power to modify the law. So, and the power of modification is far more extensive than the simple substitution of Republican personnel for monarchic personnel. And that's shown by Lord Bingham's analysis in Matthew at paragraphs 50 to 53. You've got that at EB 561 to 562. And he cites there Chief Justice de la Bastide's judgment in Rudall, which makes it clear that modification is not constrained to matters of mere nomenclature, but extends to matters of substance, as he says. Then we do submit that in performing this task of looking at the whole thing harmoniously and in its historical context, the preceding case law in the Caribbean generally and in the Court of Appeal of Trinidad cannot be ignored, as my learned friend Mr. Hussain effectively ignored it. The fact that there was already a recognised distinction between modification to ensure conformity on the one hand and invalidation on the other informs any fair and reasonable interpretation of the word invalidate in Section 6, so that it is what is prohibited is the thing that is the last resort, according to the judgment in Beckles and Delamore. That's to say where all else fails, when you can't modify, then you would invalidate, and that's what is prohibited. And that affords a powerful ground for reading the word invalidate in the way that we respectfully submit it should be read. Now, my learned friend Mr. Hussain yesterday and my learned friends today have launched an attack on the Caribbean Court of Justice's judgments successively in Nervais and McEwen. And my learned friend Mr. Hussain made an eloquent but rather extravagant argument for Trinidadian exceptionalism. But Trinidad's a member of the OAS. It's bound by the same international obligations by the American Declaration as the rest of the Caribbean Commonwealth. And it has a constitution with many similarities to the constitution of Barbados and Jamaica. I do respectfully submit, when he suggested that there was something utterly unique about Section 6, you've got a parallel in Section 26 of the Barbadian Constitution, which is at EB 783. You've got a parallel in 26.8 and 9 of the Jamaican Constitution, which is again in the second volume. And arguably, it's less drastic in the exclusion of challenges than the provisions of Section 26 of the Barbadian Constitution. And moreover, the kind of provision which says, which deals with the continuity of a law that amends in some significant way the Act. You've got that in 26.2 of the Barbadian Constitution. You've got it in 26.9 of the Jamaican Constitution. There's nothing special about Section 6.2, and we respectfully submit that the interpretation that we've advanced makes complete sense of it, that you can invalidate, that if you add something which additionally is unconstitutional, then that can be removed, and then you revert to the existing saved law. And my learned friend, Mr. Hussain, suggested that the reasoning of the Caribbean Court of Justice in Nervais was wholly inapplicable to Trinidad. Now, we accept that insofar as the reasoning goes to, this is a constitution drafted by the colonial office, as it were, at the time of independence. That doesn't apply where you've got a republican constitution by an independent state. But look at what actually happens. The 1962 Constitution saves existing penalties, for example, flogging and mandatory execution, subject to modification. If the 1976 Constitution is then interpreted in the way that the states say it should be interpreted, the penalties that are saved and the bad old laws that are saved are the colonial laws. They're the laws which said you can't be admitted if you're blind or if you're homosexual, the laws that say that flogging's okay, and that the mandatory death penalty, unless modified, is okay. So it's perfectly legitimate for the Caribbean Court of Justice to say that the effect of these savings clauses generally is to preserve from constitutional scrutiny by the courts whose task it is to protect unpopular minorities, is excluded. It's perfectly legitimate for the Caribbean Court of Justice. And the attacks on Justice of Appeal Saunders and Sir Dennis Byron, one has to remember, if it wasn't for them, the whole attack on the mandatory death penalty wouldn't have started. It was their judgment in the Eastern Caribbean Court of Appeal which led the way to Reyes, Hughes and Fox. They were the first who said, we can't follow Ong Ah Chuan. We can't follow Ron Nyoa. And so we respectfully submit that some sensitivity to the fact that they rightly said, those two judges, in the original case of Hughes, that that they would not follow the old savings clause type approach in Ranyoa and in the Ong Ah Chuan case, that led the way, and the Privy Council then adopted that approach. And the second point I'd make, respectfully, is that what is left in their approach is, firstly, they had to look at it, because in the Inter-American Court had condemned Barbados for having a savings clause which prevented Barbados from even scrutinising the mandatory death penalty. And I've given the court the references, but they're in the same. The Caribbean Court of Justice was following the Inter-American Court, which had actually, in the Boyce and Barbados case, said the state, and obviously that meant the court too, must examine the issue of the savings clause because it's inconsistent with the right to life to exclude any possibility of judicial scrutiny.
The difference which would strike this court is that the CCJ is acting as the highest court in the internal legal system of Barbados, whereas the Inter-American Court is adjudicating on Barbados's international obligations.
Yes, but the international obligations were then informing the approach of the Caribbean Court of Justice.
Well, effectively they were. There was
They were saying...
There'd be a question under the approach followed by the board as whether they ought to be given such importance.
If the principle in Neville Lewis of this board is that so far as possible, one should interpret a constitution to give effect to international obligations. So far as possible, not where there's ambiguity, but so far as possible, one should give effect.
That sounds like a bit of an outlier.
Oh, sorry?
That sounds like an outlier.
Lord Hoffman in Boyce says expressly that that principle is only engaged where there's ambiguity in the relevant provision.
Well, in Neville Lewis, they use the words so far as is possible.
Yeah, but Lord Hoffman says, oh yes, the rubric, so far as possible, means
I see.
only where there's ambiguity.
Yes. Well, my Lord, it may be one then has to strain for ambiguity, but I mean, but certainly what Lord Bingham said was that there were two options to interpret the word invalidate here, for example. But my Lord, perhaps I've said enough in defence of the CCJ. I would just make the further point that to the suggestion that they're un-Trinidadian, the Chief Justice de la Bastide was the Chief Justice of Trinidad and then became the first Chief Justice of the CCJ. Judges Nelson, Rajnath, Lee and Jamadar were all Trinidadian judges, and all the jurisdictions of the Commonwealth Caribbean are all bound by the principles of the Inter-American Commission and Court. My Lords, there is also, I can just give you the quotation, it's at EB 4432, in the Spence and Hughes case, Justice of Appeals Saunders rejects the notion that he says, in my view, we would be embarking upon a perilous path if we were to regard the circumstances of each territory as being so particular, so unique as to warrant a reluctance to take into account the standards adopted by humankind in other jurisdictions. Section 5 imposes upon the state an obligation to conform to certain irreducible standards that can be measured in degrees of universal approbation. The collective experience of courts and tribunals the world over ought to be fully considered. There's no special reason, I respectfully submit, of geography or history that has been advanced to exclude Trinidad from the benefit of the collective judicial wisdom developed in respect of other Caribbean jurisdictions. My Lords, those are the points I make in respect of my own friend's submissions yesterday. On the separation of powers, I hope this assists the board, but I did concede in answer to my learned friend, I did concede in answer to a point put to me by Lord Sales that the separation of powers is, as it were, more static, deriving from the notion of the Westminster model. But on reflection, I think I was wrong to concede that. There is a clearly demonstrable development in the concept of the separation of powers itself, particularly in the area of criminal justice, which is of considerable importance to this case. For example, the sentence of indefinite detention for juvenile murderers, which is the subject of Mollison. In 1908, it was regarded, when the Children Act introduced that sentence in England, it was regarded as perfectly consistent with the notion of the separation of powers to sentence mandatorily to indefinite detention and leave it to the executive to decide how long that detention should be. It was regarded as perfectly legitimate. But now, following the decisions in Venables in the European Court, Green-Brown in the Privy Council, and obviously Mollison and then CPSAD, it's regarded as inconsistent with the separation of powers. And it's not just inconsistent.
Well, you say that it was regarded in the European...
Yes.
I don't remember what it's called.
Your Lordship was in it.
Venables and Thompson. It was regarded as incompatible with Articles 5 and 6 of the European Convention. In other words, it was incompatible with the right to a fair trial because a trial by an independent and impartial tribunal included sentencing in a meaningful sense
Yes, my lord.
by an independent impartial tribunal. And Article 5.4 required reviews at a regular interval by an independent body, which didn't exist either under that system. So in Trinidadian terms, there was a breach of sections 4 and 5 of the Constitution.
Yes, but my lord, but I would also say that it violates the concept of the separation of powers, because basically the Parliament is making the judge impose a sentence that is inappropriate, that is cruel.
The separation of powers is built into the idea of an independent, of trial by an independent tribunal.
Yes, my lord. Yeah, my lord, I accept. Well, my lord, I will have to address that point, but what I'm respectfully submitting is it's quite clear that the apportionment of power as between the legislature, the executive, I mean, why do your lordships have to sit in this building rather than the House of Lords now? Because there's been a progression in concepts of separation of powers. The examples are countless. It isn't static. Even in the UK system, the notion that you can leave that Parliament can just entrust the power, just force judges to impose a particular penalty, and then leave it to the executive. Look at the change of the mandatory life sentence. That without it wouldn't have been saved in the case of Lichniak without the power of the judiciary to determine tariffs. Lord Bingham said it would have been cruel and unusual punishment, but for an inhuman punishment, but for that. And underlying that, my lord, is, in our respectful submission, concepts of the separation of powers. What is it appropriate for Parliament to force a judge to do? What is it appropriate? When is it appropriate to leave these matters purely to the executive? And so, my lord, I do respectfully submit that the legislative prescription of a penalty to be imposed by a judge, irrespective of the merits of the case, isn't consistent, certainly in relation to the death penalty, with modern ideas of the separation of powers.
But the difficulty with that argument is that in this jurisdiction, it all relies upon the European Convention on Human Rights, and in Trinidad and Tobago, it all relies upon their constitution. Yes. So you're thrown back to the constitutional argument.
Yes.
Here you rely upon Article 5 and arbitrary terms of imprisonment. And there's a lot of authority in relation to that, in relation to firearms offences and life sentences.
Well, my lord, I accept that, but can I just take it one step further? One of the reasons why it's regarded as a violation of Article 5 and is because it's regarded as arbitrary.
Yeah.
And arbitrariness goes to the rule of law. Now, if the rule of law, si caerati, is there already in Section 1 of the Trinidad Constitution, then in our respectful submission, it's a violation of the rule of law as well as the separation of powers. And that isn't, therefore, the attack is not solely confined to Section 4 and 5. It's wider. And the fact that normally one doesn't have to have a resort to that because you've got Section 4 and 5 and the ready-made remedies doesn't mean that it isn't a violation of the principle of the separation of powers and the principle of the rule of law, which, in accordance with caerati, can be read into Section 1 of the Constitution. And then, of course, my Lord Hughes put to me, well, how does one distinguish between the separation of powers principle applicable in the asserted principle applicable in the death penalty cases from all other mandatory penalties? And we say respectfully the answer is that the imposition of the death penalty particularly requires an individualised consideration by a judge. And again, if you go back in Ong Ar Chuan, the board was saying there's absolutely nothing wrong with fixed penalties because we have fixed penalties for driving offences. So, and basically, Lord Bingham regarded the reasoning in Ong Ar Chuan as obsolete in Ray's. I can give you the reference. It's at EB 707, paragraph 45. It does make a difference what the penalty is. And can I just give you the references in our case? Our case, we deal with the question of the violation of the separation of powers from paragraphs 32 onwards, and the court has Justice Saunders' judgment in August there, where a fixed penalty can be seen with certainty to be seriously disproportionate in some cases, it would not only be inhumane, but a violation of the separation of powers. That view then held over into the Nervais case, and we've relied on that. And we've relied on the fact that the mandatory nature of the death penalty is antithetical to the separation of powers doctrine. And you have further on what Justice Anderson says: the separation of powers forbids the legislature from compelling the judiciary to impose a sentence that is cruel and inhumane, and one that is widely held to be contrary to human rights norms. And so we do respectfully submit, and really we developed that point at paragraph 36 onwards in relation to Dodo and the international Roth decision, where Lord Justice Laws says that a fixed penalty cannot stand unless it can be adjudged proportionate in all cases having regard to the culpability involved. Now, our respectful submission is this is not just about the arbitrariness of the penalty in the context of an Article 5 or Article 6 attack. It also goes to the legitimate separation of the powers as found by the CCJ and observance of the rule of law. My Lord, that is the argument we make in response on those points. Now, can I then just go through the points that my learned friend Mr. Stevens made very briefly? He said that Nervais was of no assistance and introduced nothing new, but what Nervais explains in our respectful submission is why savings clauses are contrary to the fundamental judicial policy that it should be judges who protect fundamental human rights. And so that concept of judicial policy in the Nervais judgment is important. So too, we respectfully submit, is the sentiment that savings clauses should be restrictively interpreted so as not to shut out judicial consideration of whether human rights, fundamental human rights, are being observed. Now, my learned friend said then there's no new argument there. Actually, you don't need a new argument. If you look at the big changes, the big developments in this board in relation to the death penalty, Pratt and Morgan, there were two decisions to the contrary. Riley, again, where Lord Scarman and Lord Brightman had given powerful dissents but been overruled by the majority in 1975. 15 years later, this board simply said they were wrong. And they said they were wrong looking at international matters, the Inter-American Court and the European Court of Human Rights, but in relation to the death penalty, all that's been said today could have been said then. You're just repeating the arguments that Lord Scarman and Lord Brightman said in their dissent in Riley. But that didn't deter the board, 7-person board in that case, in Pratt and Morgan, from reversing Riley and reversing De Freitas and Benny. The second thing is Neville Lewis. There were two authorities which said you cannot judicially review the prerogative of mercy. De Freitas and Benny was one of them, and a very recent decision of Reckley was another. And in Neville Lewis, which you've got at page 3178, if I can just paraphrase it, what the board said was, stare decisis is a good thing, but justice is a better. That's tab 85. It's at page. So the idea that what you may have to have is some development of values, but we have that. We've got the Supreme Court in the Caribbean saying that this needs looking at again. And yes, that's Lewis and the Attorney General, page 3178, the position in each, and they talk about Reckley, was given as recently as 1996. The need for legal certainty demands that they should be very reluctant to depart from fully reasoned decisions unless there are strong grounds to do so, but no less should they be prepared to do so when a man's life is at stake, where the death penalty is involved, if they are satisfied the earlier cases adopted a wrong approach. Just 5 years after that. So, and all these arguments about, well, all the Caribbean jurisdictions have been operating on the basis that the prerogative of mercy was unreviewable, you mustn't do it, the sky will fall in, were deployed in Neville Lewis, and yet, because of the importance of the issues, the board simply looking at the issue in a wider context reversed the Reckley decision. And so, my lords, what we...
Mr. Fitzgerald, could I ask?
Yes, ma'am.
Is your argument running by reason of the decision in Nervase, or would it run in any event, irrespective of the decision in Nervase?
Well, my lord, I think Nervase was the reason why the board gave permission, and as it were, triggered it. But of course, Nervase also built on the decision of the Inter-American Court in Boyce, so that was an international development in 2007, which post-dated Matthew. And my lord, yes, I mean, if you look at a case like Neville Lewis, it was it was autonomous, as it were. It was just the board, because of the importance of the issues, took another look at its earlier decision and reversed it. Pratt and Morgan was a mixture of international developments, the Inter-American Court and the European Court in Suring, and what Lord Griffiths just said, advancing concepts of our humanity. So it can be. I think the answer is it's both, my lord. It's both. But what we do respectfully submit is that my learned friend said there's no enlightenment, as it were. There's no light shed on these issues by Nervase and McEwen, and we say that's not right. They look at the two rationales at paragraph 11, page 649, and my learned friend fairly took you to those. And the first one was they thought that all the rights were already secured, the Nasrallah thing, which is, that's patently ridiculous to continue with the fiction that all rights were already secured in, as it were, the colonial system. And quite rightly, the CCJ says that doesn't stand. Then the second one was it's a reasonable working assumption for transitional purposes. And the CCJ pointed out we can't carry on transitioning forever. There must be some time when we arrive, as it were. And so they gave a counter rationale, which was that the momentum is towards the restriction of savings clauses, assisted by the fact that the Inter-American Court had said that it actually violates the international obligations to have a savings clause of this nature. And I gave the board the reference, and that it restricts the power of the court to protect fundamental rights. And so when they said, again, it's been, as it were, parodied and mocked when they said forever prevented from giving effect to human rights. Well, it's quite true that the legislature could pass legislation and put it right, and could amend the Constitution and put it right. But my Lord Stevens asked my learned friend, well, what have they done about it? About the fact that it's admitted that it's a cruel and unusual punishment, and was admitted in 2004 that it was cruel and unusual. The answer is absolutely nothing, and the reason is obvious, and it's the reason why we have human rights protections, because nobody cares about the rights of convicted murderers. And equally, I suppose the same would be for those excluded under the Immigration Act, which somehow it's important to protect as a saved law, excluding homosexuals and blind people from access. That won't be looked at because there won't be, as it were, a groundswell of democratic votes to be gleaned from reviewing that ban. So the reality is the reason, and I know it's self-evident, but it does need spelling out, the reason why, again, the CCJ, who know the world they're dealing with, are saying forever shut out, is because unless the judiciary intervene, it's unlikely that the legislature will change things. And so, my lords, that's my respectful submission. And, my lords, my learned friend went through the case of McEwen. We do respectfully commend the interpretative approach, 4 principles of interpretation that Justice of Appeal Saunders develops there: the restrictive interpretation of the savings clause, the approach to international law and the Boyce and Barbados case by way of background, and the idea that it's only the enumerated human rights provisions that you can't rely on. And then finally, there's the point about taking the 2 provisions as a whole, the modification, reading it together with the exclusionary clause, the existing laws savings clause. And we do respectfully submit that it is, as it were, at least a new perspective from the highest court in the Caribbean justifying a review so as to achieve some harmony throughout these closely related states. After all, my learned friend was saying, Mr. Hussain was saying it's only 5 miles from Venezuela. Well, it's equally very, very close to Grenada, which is governed by the Eastern Caribbean Court of Appeal. And so my lady put the point about developing a new jurisprudence. I respectfully submit it's developing a new approach to the need for the protection of human rights. So it's the same point, really. And then my learned friend, Mr. Stevens, made a number of points about the interpretation of Section 6.1, and his first wrong proposition in our submission was he said Section 6.1 makes the existing law constitutional. Well, that's contrary to what Lord Hoffman himself says at paragraph 12 of Matthews, where he says it is inconsistent with the prohibition on cruel and unusual punishment. It doesn't conform with the Convention. Section 6.1 does not make it conform with the Convention. It just says you can't invalidate the whole law. My learned friend said the linchpin of our argument is the different language. We say that it is an important part that the language has changed against the background that there obviously was discussion and debate as to whether there should be a continuing savings clause or not. And Lord Bingham's conclusion that looking at the historical materials was inconclusive, we say, was correct. But we do say that the respondents simply ignore the history of that word invalidate and the specific history which can be derived from cases like Beccles and Delamore. My learned friend then said that our interpretation robs a savings clause of any real content. What does he mean by real content? Does he mean that Section 6.1 has got to exclude a lot of things or it shouldn't be there? All it needs to do is to serve a discernible purpose consistent with the approach in cases like Beccles and Delamore, and actually consistent, for example, with the approach under our Human Rights Act. That there are certain things you can do and you can modify, but where you come up with a brick wall that the only thing you could do is to invalidate the whole law or the whole purpose of the law, you can't do that. And that's not perverse or irrational. It happens every time when we make a declaration of incompatibility here. We say, well, we can't go that far. And indeed, that respects parliamentary sovereignty, because it says there comes a point at which the modification power has to stop, and you can't invalidate, and therefore the law remains. Now, Lord Hoffman said, oh, that's ridiculous. No lawmaker in their right mind could possibly conceive of doing that. That's exactly what we did with the Human Rights Act. We said there's the point at which you can interpret. There's a point at which all you can say is it's flatly inconsistent, and we'll leave it to Parliament. So it is far from, and this idea that because that saves the most egregious things, what it does is to save those laws which are so clearly inconsistent with the human rights that you can't save them by modification. And that's a perfectly discernible and understandable approach, which is followed in many constitutions. I think it's the New Zealand Constitution also. So Lord Hoffman's great trump point was no one in their right minds could interpret it in this way because it would result in complete lunacy. In fact, it results in a perfectly understandable, comprehensible, and rational system, and it leaves Section 6 with a perfectly reasonable function, and it's simply untrue to say that there's no purpose, and it's pretty insulting to the extremely distinguished minorities to say no one in their right minds could interpret the statute in that way. As to my learned friend's points about 6.1b, 6.1c, and 6.2, I've respectfully submitted that you can make sense of those two, and actually they're no different. They're just variations on a theme on what you have in the Barbadian Constitution and the Jamaican Constitution. So, my lords, those are my submissions in response to my learned friend, Mr. Howard Stevens. My learned friend, Mr. Poole, I think I've really sought to answer those points, but we say it is an independent ground. Johnson itself, volume 7, tab 78, I think is 2868, recognises that you can sometimes rely on things other than section 4 and 5. And we respectfully submit that there's no doubt in Mollison, there's no doubt in the case of Green-Brown also, that you can rely on the separation of powers because it's not contained in section 4 and 5. And it's wider and more pervasive, and it has been relied on in a number of cases. We are not in Lendor territory. We are not relying on the complaint that this is the executive sentencing. We're relying on the complaint that Parliament has forced judges in many cases, and at least in some cases, to impose a penalty which on any view is cruel and unusual, and that is inconsistent with the judicial function. And, my lord, that's our central argument, and we've developed that. I won't read it all out, but your lordships have that argument set out in some detail in the under the headings of separation of powers from page EB 277 onwards, citing August Nervais, the Roth case, and the Cable case, and also the Ferguson case. I do draw attention to 281, where Lord Sumption says it can, at paragraph 44, the citation, it can violate the separation of powers to force the court to dictate to the court the penalty to be imposed, and he cited with approval the judgments of Justice Gaudron and McHugh in the Nicholas case. You have those set out, which brings the administration of justice into disrepute by, as it were, telling the court, that it must impose a particular type of sentence. And the same is true of the judgment, the citation from the judgment of McHugh. So, my lords, we respectfully submit that it's in that very specific way that it violates the separation of powers, that it compels the judge to impose a penalty that they regard and that anyone would regard in some circumstances as a cruel and unusual punishment. And then that also, for the same reasons, violates the rule of law, and we've dealt with that in the case from paragraphs 55 onwards. But my own friend said, well, Francis was a totally different case. It was about the protection of the law. That was the mandatory minimum sentence of 25 years for possession of intent to supply. But what Francis was it violates the protection of the law because it's arbitrary. And our respectful submission is that if there is a systematic requirement of the judiciary to pass sentences that are arbitrary, that violates and undermines the rule of law. The rule of law is there in section 1, see Kairati, and it's there pervading the Constitution. Therefore, it's not reliance on section 4 and 5 as such, but on a principle that is contained in section 1, which is itself enforceable, as Lord Steyn said of a similar provision in Mauritius. And it's a complete red herring to say that was all because it was deeply entrenched. It's a question of the meaning of the words, sovereign and democratic. What does the word democratic mean? If it carries with it the implication of observance of the rule of law, then it doesn't matter whether it's deeply entrenched or not. It's a requirement of the Constitution. And a violation of it is a violation of the Constitution, and to require the judiciary to act contrary to the rule of law would be unconstitutional. My Lords, I think those are my points in response. My Lord, so for all those reasons, we respectfully invite the Court to make the necessary modification, and we say it's not prevented by Section 6 of the Constitution.
Thank you very much, Mr. Fitzgerald. This is obviously an important case where there's a lot to be said on both sides of the argument. I can say with greater sincerity than is necessarily always the case that we're very grateful to all counsel for their assistance, and also to those behind them who've no doubt assisted in the preparation of these arguments. The Board will now take time to consider its judgment.